on their wooden porch, pouring kerosene with them still inside and their baby.
Case of People versus Mary Barney.
Is that not behalf of people?
Assistant Public Defender Chelsea Virgil, on behalf of Mary Barney. Please state your name. Mary Barney. I turned in a green sheet regarding the PCC. We're asking to adjourn that.
Okay. And as to your motion?
As stated in the motion, I'm asking for release to inpatient treatment. I think that for Miss Barney, it's kind of a monumental time for her. It has taken her a very long time to come to terms with admitting that she has a substance abuse issue and admitting that contributed greatly to her criminal history. She wants to get treatment. She wants to do better and be more stable.
Pause right here, because this is the moment the entire hearing pivots. This isn't just about substance abuse anymore. This is about public safety. Prosecutors are framing this as an escalation case. Assault history turning into potential arson with people, including a baby still inside. In bond hearings, that word egregious is doing heavy lifting. It signals to the judge this defendant isn't stabilizing. She's escalating. And once that narrative lands, release becomes an uphill battle.
For her kids, and she's already actually starting an initiative on that. She's doing AA at the jail. She's on the wait list for Dawn Farm. And you know, all around trying to improve herself. We have no objection to a scram tether or a GPS tether if she is released to treatment. She just really wants that intensive opportunity to better herself.
Response.
Your Honor, at this time I'm going to strongly object. Her criminal history includes pretty much only assaulted crime. She has an aggravated assault from 2023, a child abuse, fourth from 2024, an assault with one of the same victims in the current case, I believe from 2024 as well. And in this case, she is exhibiting a clear escalation in violence where she is at the residence, setting their car on fire on camera, on their wooden porch, pouring kerosene with them still inside and their baby. I mean, it's egregious. And I have concerns that she is a serious danger to those people, and she could have, if not caught before she set the fire on the house, could have killed people. And I mean, I get that it's a big step for her to take accountability for her issues, but I also think that she can start that treatment in custody doing Dawn Farms and AA. And I have concerns that if she were to get out to inpatient, if she were to leave inpatient, what that would mean for the community. She's obviously ramping up her violence towards other people, and I have concerns. She also, I did mention, there was another warrant that we did review and did charge her. I don't believe she's been arraigned. It was done this week. She now has another case with 4 counts of child abuse, 4th degree second notice, which are felonies, in relation to this case.
So, hold it. There's another case coming?
Yes, there's another case coming that is related to this case where she left the children to go commit this crime and was charged for that action. I have concerns that she's been given numerous opportunities with her probation to change.
Here's the legal gut punch. Pattern behavior. The court isn't just weighing this incident. It's weighing her entire track record. Violated probation. Ignored a protection order. New charges tied to the same event. Judges are trained to ask one brutal question at this stage. If I release her today, what stops this from happening again tomorrow? And right now, the prosecution is answering that question for the court very convincingly.
Behavior, doesn't do it, violates probation, and then comes back here with the more serious, more egregious felonies. I just have significant concerns for the community. She was unable to follow a PPO. That one of the victims in this case has a valid PPO against her. That didn't stop her from going to the residence and setting fire to the car and potentially to the house. So I mean, I think she's a significant risk to the community, to the victims. She cannot follow court orders, as she has shown by violating a PPO and violating previous probation. So I think at this point, the safest place for the community and for Ms. Barney is for her to remain in custody. I have concerns that if she were to get out to inpatient and just leave, even with a tether, I don't know what she would do at this point. So I don't think it's appropriate for her to be released to treatment at this point.
Anything else?
I did become aware earlier that there are new charges, but there are not new facts. That is from the same incident. The same facts that we have all been aware of the whole time are, you know, she maintains that those are just allegations at this time, and that alcohol was a contributing factor. I think that this time is very different for her, that in the past when she had these incidences that she was in denial that alcohol was contributing. She did not have the commitment that she has now to change the trajectory of her life. And I think that all the efforts that she's engaging in at the jail show that she wants to be in this treatment. I don't think that she would leave the treatment. And I believe that the tether would be adequate if she were to leave, which I don't think that there are any circumstances which she would. You could go get her immediately.
Given all the circumstances, well, let me say this first, and I don't know if council's aware. Bernie was received by the court on December 9th, a 3-page letter.
I have not seen it.
You have not?
No.
And I'm presuming you haven't. Okay, the court will provide the parties a copy of that. However, given all of the circumstances of this, the underlying case, and now there's a new case, I understand that it may fall from these incidents, but new charges coming as against this defendant. The court is going to deny any request for modification of bond in any fashion whatsoever. Let's take a look at the letter because
And there it is, the denial. This decision isn't punishment. It's risk management. The judge is signaling that treatment, accountability, and safety can't be balanced outside custody right now. That unexplained 3-page letter? That's the wild card. Judges don't flag documents like that unless something inside raised serious concern. Bottom line, when credibility, compliance, and community safety collide, bond is the first thing to go.
certain things within this letter that may or may not cause some concern. And so what I will do is deny a request. Bond will continue in its current. All right. And I will set this for December 23rd, 2025, 9 a.m. All right.
Thank you.
Thank you.